Hello and welcome to the latest OC Regen video. And today we're going to be looking at joint ventures in the context of Regen schemes. My name's Sarah Knight and I'm a corporate real estate partner here at Osborne Clarke. And we're going to be looking at disputes in relation to JV schemes. And I'm delighted to be joined by Becky Crawford, who's an associate director in our disputes and risks team. Hi, Becky.
Hi, thanks for having me.
Now, when we think about joint ventures in the context of regeneration schemes, we often see them as a long-term partnership between the parties. So both sides being committed in terms of resourcing, funding, and ultimately for the overall strategy and outcome for the area. So Becky, against that backdrop, what are the sorts of issues that you see which can lead to disputes between JV parties? And can you give us any examples?
Yeah, of course. So there's a broad range of factors which can give rise to disputes. And I'm saying that because they don't always. So the examples I'm about to give aren't necessarily a huge cause for concern. But the types of issue we see broadly fall into two separate categories. So on the one hand, you've got commercial issues, and on the other, you've got human issues. If we start by thinking about those commercial issues in a bit more detail, it may well be, for example, that there's a concern by one of the JV partners about the viability of the project. So there might have been a change in economic circumstances or a change in government policy. Another key thing that we see quite a lot is one JV partner really perceiving that there's been a change in resources or time or commitment that they think that the other party is dedicating to this project. And that party might just be thinking, this could really impact on the successful outcome of this JV. Linked to that, perhaps, there could be a change in the scope of the JV or a change in expectations among those different partners. And one of the causes for that sometimes is that there's also been a change in owner of one JV partner. And that can give rise to tensions, particularly where the other partner perceives that new owner as a direct competitor in their same industry or sector. And then finally, I think on the commercial factors, it's worth considering where one partner has a dual role. For example, they might be a developer as well as a JV partner. And when they're wearing two hats, that can be tricky to manage and manage those expectations too. So those were the commercial factors we see a lot of. The human factors we probably see a great deal more of. So that might be something to do with a real divergence between how that JV is managed day to day versus what the underlying contract says. And it can often happen that somebody feels that they've got a really good day-to-day on-the-ground relationship and they just don't need to look at the contract. It might also be that there's just no awareness of what that contract says, and that often happens. The day-to-day operations and the legal mechanics are slightly at a different shift to one another. And then finally, there's the impulse to hide mistakes and perhaps even avoid the lawyers, when actually if you involve us early enough, we can try and implement a strategy to navigate that risk and hopefully reduce the likelihood of a dispute coming up in the future.
Great. And are there any early warning signs that a dispute could be on the horizon?
Yeah, so there's a few early warning signs on the operation and the day-to-day management. You might find that one party is failing to cooperate, or perhaps they're delaying in making decisions or failing to attend some of the supervision or oversight meetings. And that can be a sign that there's an issue coming up or there's a reason that they don't want to engage fully. Another issue we see quite a lot of is where there's a defined stage in your project and one party is really keen to move on to the next step without the first one being fully completed. And then I guess another key one in the day-to-day running that might be more obvious as a red flag is where there's looking to be some really key financial irregularities in that project. And obviously that's going to be a sign that all is not well. It's not just the day-to-day management though. I think it's probably also worth mentioning paper trails. So if you see emails from the other partner saying that they're reserving all rights, that would seem to be quite a clear warning sign that they're looking to bring an issue further down the line. And perhaps less obviously, they might also be sending emails saying things that look polite or even constructive on the surface. So they could be saying, we've got concerns with a lack of progress or a lack of participation. But those emails, especially over a period of time, they look to be building up a bigger picture of non-compliance.
And do you have any practical tips in terms of managing the risks of JV disputes?
Yes, certainly. And I think it's worth saying that not all JV disputes look the same and it's not a one-size-fits-all approach here. But and it will depend on things like the value of the JV, its nature, and what the particular issue is that's arisen. But against that backdrop, I think there's probably three key tips that all JV partners can adopt to really reduce that risk. The first one is to put in place a contract management template. So that might record the parties' key obligations, any crucial deadlines, perhaps requirements that are slightly unusual for your business, as well as what the oversight meeting structure should look like. And once you've got that template, you need to make sure that the people running the JV are aware of it. We all know that having these templates and policies are only so good. People need to be aware of them for them to actually add value to your business. Secondly, you need to ensure that your employees are identifying any divergences from the contract as soon as possible. And ideally, they should be escalating that within your business or engaging the legal team, just so that once they're involved early enough, they can navigate those risks and hopefully reduce your exposure going forward. And then third and finally, it's worth thinking about the paper trail. So we've spoken about that already in the context of warning signs. But where you know there's a dispute on the horizon, it's really key to record any decisions, put them in writing. If there's any communications with the other partner you might want to refer to in the future, make sure that those are in writing too. And if you have notice provisions you need to follow, make sure you're lined up with those as well.
Thank you. Those are really useful tips. Thank you. As they say, easy to marry, but hard to divorce. And I think that's certainly the case in the large regen schemes that we act on, where our clients are so invested in them. Thank you so much, Becky, for your time. Thank you for watching, and please look out for more videos from OC Regen.